As we all know, that Constitution, since its inception, has been evolving itself. And once you have Parvathi Menon A, advocate from Kerala High Court, you know that whatever she speaks will be an ounce of knowledge, which everybody will be cherishing. And the manner in which there has been an evolution of women-centric laws in India is today's topic, what we'll be delving upon and discussing it through Parvathi Menon. And we have done a lot of sessions with her, and all her sessions, needless to say, are doing extremely well. And we are indebted that she has accepted our invite. Over to you, ma'am.
Thank you, sir. Thanks a lot for that good introduction, very motivating introduction. And as much as the topic is concerned, the topic relates to the women-centric laws, basically as a result of the constitutional evolution. So anything, as we know, like the whole of this country is indebted to the Constitution. We are bound by the Constitution. And it's something called a constitutional culture that has to be imbibed, or that has to be developed in this country as a whole, not alone by the legal fraternity, but as much as by the entire country as a whole. Now, that be so, if that be so, what I intend to flag upon is how the Constitution has been, right from its inception, the important provisions which have been already there in the Constitution, which are women-centric, which are for the benefit of the women, which we start with under Article 15, Clause 3 of the Indian Constitution, which reads that, as we all know, Article 15 clearly states that no Indian citizen can be, they cannot be separated, or rather, there is no point in any kind of discrimination that can be showed against people on the basis of religion, race, caste, sex, or place of birth. In spite of such a provision under Article 15, we have a specific clause under Article 15, Clause 3, which reads that any laws that have been made for the benefit of women and children cannot be considered to be in ultra vires of the Constitution. So the beneficial legislations which have been made, any statutes, any law that has been made or formulated exclusively for the benefit of women and children have been considered to be virus. It has been considered to be very much constitutional. And that's how the Constitution at the outset itself protects the women-centric laws and women and children of this country. Then comes Article 39 of the Constitution. Article 39 of the Constitution, which ensures the benefit under the directive principles of the state policy, which clearly states that it ensures and directs the state to apply policies which focus on men and women equally. That is, Article 39D goes to a very focused provision which says that, which reads regarding equal pay for equal work. So right from the inception, there is no point in saying that the Constitution or this country was completely patriarchal to a stage where, to a state where people, when nobody was concerned about women or children. It's not like that. Right from the inception, the Constitution makers were very much far-sighted. They saw to it that women and children were protected as per the main provisions of the Constitution. All the same, in spite of highlighting these provisions, something which I would like to bring to your notice is, unless and until society feels, because the difficulty is not just in the lack of having statutes or lack of having legislations. The difficulty is basically what we understand as a part of this fraternity, we understand is generally the attitude of the people, of the society. See, unless and until the unless and until the society needs a change, there is no point in bringing about as much as laws as possible. Because, for example, I'll give you, we have had the Dowry Prohibition Act as early as 1961. We have had the Child Marriage Restraint Act as early as 1929. But don't you think we still have child marriages conducted in some parts of the country? We still have the dowry system that is prevalent in the society. So unless and until you and I need the feel in the change, that a change has to be brought in the society, unless and until that happens, there is no point in bringing as much laws as possible. So it's not a case where we do not have laws, necessary laws. It's a case where how we use the laws. Because as far as Dowry Prohibition Act is concerned, let me tell you, it's very, very rarely that people invoke the provisions of the Dowry Prohibition Act and make complaints before the authorities. Dowry prohibition officers are sitting idle because nobody goes to them, nobody complains to them. Child marriage officers are also sitting idle because nobody complains to them. But of late, at least in our state in Kerala, people have started reacting and responding. And so, of course, generally, unless and until the society feels the necessity for this change, we will not be able to make use of the laws that have been enacted by the legislature for our benefit. So Article 39 is there, 39C and 39D specifically states that we should focus on laws that should be centric for both, that should be beneficial for both men and women. 39D clearly focuses on equal pay for equal work for both men and women. Then Article 42 of the Constitution casts a duty on the state to make provisions for securing just and humane conditions of work and the necessary relief. So we have a lot of, labor laws as well, which protect the rights of women, the rights of feeding women. The women are not allowed to work at night, at odd hours, in mines. At the same time, maternity benefits are given to them. Maternity leave is granted to them. They're given facility for breastfeeding. So considering the biological difference in men and women, it's not a case of difference in gender and sex. Please do not, as much as we speak about gender sensitivity, we should also realize that the biological sexual difference should be considered with some kind of parity, and with respecting that, we should be able to make laws. For example, what we actually need is uniformity in our rights and not uniformity in our law. That is, I'll come to that. After Article 42, another important provision in the Constitution is Article 51, Clause A, C. Article 51, Clause A, Clause C, which is one of the fundamental duties, which provides, clearly states it, that the state has the duty to see to it that renounce practices which are derogatory to the dignity of women. So the dignity of women has been upheld by incorporating the fundamental duty under Article 51, Clause A, Clause C. Then, of course, we have the constitutional rights, or for that matter, any kind of violation of legal rights, a person can approach the court of law, irrespective of whether they are men or women. So that way, after giving you an introduction as much as to how the Constitution has been protective enough in order to bring about women-centric provisions in it, let's see how it has developed over the years. We know how the women-centric concept has developed over the years, because right from the beginning, if we think of it, as I earlier told you, we had the Child Marriage Restraint Act as 1929. It was a sociological reform which was sought to be brought about because everything is entangled with what is happening in the society. We had polygamy, we had scant respect for women. It was more or less the women-centric laws, and its evolution was more or less on a roller coaster graph, because there are times when women have been given their due respect, which has changed, and then there were times of dips when women were not given importance at all. Then again, the social reformers thought that most important thing, we had the abolition of sati, we had the abolition of child marriages, we had remarriages of widows allowed. So it was again a roller coaster, and then again we had a dip. Ultimately, people again started violation of a woman's body, violation of a woman's independence in her economic life, in her physical, in her physical autonomy, in her economic autonomy, in her habitual behavior pattern. Everything was being interfered. So again, at every other point of time, the legislatures has been sensitive enough to feel the pulse of the society and to create laws in such a manner, that they are useful for women. But again, the difficulty was women were unable to make use of these laws. They were unable to approach the courts of law. They were unable to stand up for themselves, at least to talk to their own kith and kin and say that I'm suffering from this. Why? Because the societal structure was in such a manner that women were expected to be submissive. More submissive she was considered to be more divine and more beneficial to the family. So that concept itself made her not use the laws that have been enacted in her favor. So let's see, 1937, we have had an act which says Right of Hindu Women to Property Act in the year 1937. But that act had was exclusively only for the purpose, like only when that a Hindu widow would have right to the property that has been left by her husband in her husband's family. Whatever right she gets, but that again was a very limited right. She had the right to life estate, she had the right to maintenance, but she did not have, she had the right to seek for partition only to the extent of getting that property exclusively for her for the sake of life estate. Life estate to the meaning that she can stay in that house till she dies, and secondly for her maintenance. She did not have absolute right over the property. So whatever right that she got as a result of the 1937 Act did not say that she had got absolute right over the property. At the same time, in 1939, we had the Dissolution of Muslim Marriage Act also in 1939. That is something which is very much alien to the Muslim community, in the sense, even now, I think it's only very recently after Khula has been recognized as a proper extrajudicial form of divorce by the courts of law, that we Muslim women have come forward to take a step, or rather to take the initiative to dissolve the marriages. Otherwise, among the Muslim community, no women came forward, in spite of having extrajudicial forms of divorce, and also a statute for that matter as early as 1939, which read grounds like cruelty, abandonment, like if you have been completely left in lurch, deserted by your husband for more than 2 years. All these grounds were available in Dissolution of Muslim Marriage Act 1939. Still, there were nobody who used to take up that issue, or rather approach the courts of law. No Muslim women dared to approach the courts of law by invoking the provisions under the Dissolution of Muslim Marriage Act 1939. So 37, the Hindu women had the right, had a legislation to their credit, or rather to their benefit. 1939, the Muslim women had. Christian women also had different rights, but not equal to that of men when it came to succession. The Indian Succession Act also had to undergo a lot of amendments to bring it to parity, so that the men and women had the same equal rights, or rather the sons and daughters had equal rights over their father's property. Now, what has happened is, in 1956, the Hindu Code came into being. 1956, the Hindu Code came into being, in which the Hindu Succession Act came into force. By the time when the Hindu Succession Act came into force, we had Section 14 of the Hindu Succession Act, which clearly stated that whatever right the woman gets, all in the self-acquired property or be in the ancestral property, whatever right she got would become absolute right. So it's only after Section 14 was inserted under the Hindu Succession Act in 1956 that Hindu women got absolute right over the property. And correspondingly, of course, she had Section 15 and Section 17 under the Hindu Succession Act, in section 15, which read when a Hindu female, how the interstate succession would go when a Hindu female died. The Hindu female dies interstate without writing a will, how a property would go to her sons, daughters, and husband, and subsequently to the heirs of her husband, or after that, if no heirs of her husband, to her mother and father, then to her heirs of her father, then to her heirs of her mother. But section 17 was different. Section 17 was specifically stated, Hindu Succession Act, section 17 specifically stated how the property would devolve interstate when a woman who follows Alaya Santana law or Marumakatayam law dies. So the difference in Marumakatayam law is like, it is matriarchal, it's matrilineal, whereas otherwise it's generally considered to be patrilineal. So the concept of Mitakshara, Dayabhaga schools of law, everything was codified under the Hindu Succession Act when it came in 1956. And as a result of it, women got absolute rights in the property under section 14. Her rights on death, how her property would go if she dies interstate, was decided as per section 15 and section 17. One other important thing is under section 8, when a male dies, the women were given maximum importance and they were put as class 1 heirs. Under section 8 of the Hindu Succession Act, when a Hindu male dies, his property, when a Hindu male dies interstate, of course, his property would fall on his wife. His wife means like his widow, his mother, his son, his daughter, wife, widow of a predeceased son, widow of a predeceased son's son. That is, it depends on like who all are there. But the class 1 has included maximum women. And yet again, this is something which our state, that is the state of Kerala, has done. In 2016, there has been a major amendment under section 8, which states that if a mother has received the property of her deceased son as a class 1 heir under section 8 of the Hindu Succession Act, and then subsequently the mother dies interstate, that property would revert back to the son's widow and children. So that again is a women beneficial enactment. Otherwise, just imagine, once the mother-in-law dies, the daughter-in-law is again constrained to have, perhaps, unless and until there is an understanding among the family, it's all possibility that she will have to have a legal battle with the mother-in-law's remaining legal heirs. That must be the deceased husband's brothers, sisters, or whoever it is. So in order to avoid further litigations and further legal battles, or else to bring about a quietus in the family, perhaps that is one reason. It's a 2016 amendment which has been brought about in Kerala. Of course, it is under challenge before the Honorable High Court, but no decision has come to force, and no decision has come so far, and there is no stay also in the matter. So that enactment says, once a mother dies interstate, that is, if she has written a will, it's different. If she has sold that part of the property during her lifetime, it is different. Otherwise, that property will revert back to the son's widow and children. So, and section 30 again, section 30, very, very important. Section 30 clearly states that irrespective of sex, like be it a man or be it a woman, a person can write a will bequeathing his property to any person to his liking. Need not be, he's not answerable to anyone. He can very well bequeath. It's his desire, it is his wish that he can bequeath that property. So a woman, once she gets absolute right over the property, she has every right to bequeath her property. That comes to Hindu laws. As far as Christian laws are concerned, of course, there has been a disparity in a husband's property. When a male dies, the widow gets 1/3 right, and the rest of the property, the rest 2/3 is being divided among the children. And it is different if the man dies without children, the widow gets half, and the rest half goes to her, goes to his family, his siblings, or his legal heirs. In Kerala, again, as you all know, in Mary Roy's case, it's a very important decision. It's a very decision with far-reaching consequences. In 1986, we had Mary Roy, who fought her way through up to the Supreme Court and saw to it that all women were given equal rights. Daughters were given equal rights like sons in the father's property. So these are all evolutions. Like whenever a legislature or a statute or a law is challenged before the courts of law, and when the courts of law realize that there are loopholes or that there are so many gaps, which even if they term themselves as women-centric, there are so many gaps which will not help them get the actual benefit which are expected for women. They step in and see to it that such gaps are filled and maximum benefit is given to women. So then we have a major leap. We have, of course, the Dowry Prohibition Act came into being in 1961, but it is very sad to say, since even since 1961, it's not a case where that we do not have give and take of dowry. There have been suggestions for major amendments. In between, of course, there has been amendments in that statute also, but nothing clicked well. One reason being the attitude of the society. Because, of course, initially it was to be like when a girl gets married. See, why if that is where I have to stress on something called gender sensitization. Because everybody tries to synonymize sex and gender. Sex is different, gender is different. Now, when it comes to sex, sex is something which it's a biological term which is attributed at the time of birth. The number of chromosomes and other biological. Scientifically, you are either a man or a woman, or if by any reasons you have the chromosome differences, or if for any biological reason, you can be a trans person also. Now, when it comes to gender, gender is something which you would prefer to identify yourself in the society. We all know the famous 2014 Nalsa case. So it's like tomorrow at an adolescent age, or at an age when your hormonal changes take place, you realize that there are more of male hormones in you. A woman realizes that there are more of male hormones in them, or when a male realizes that there are more of female hormones in them. It is how they identify themselves or prefer to identify themselves with the society. That is how you attribute the gender. Respect it, whatever be respected. So it's as a result of respecting that we find there are major changes that have been brought about in the Bharatiya Nyaya Samhita, which is going to come into being in July 2024. Of course, in the CRPC is also being amended. So they have added, and it's proudly I can say, Kerala is the first state to bring about a transgender policy as early as 2015. We have had it's a policy. It's not a statute as such, but we have had a transgender policy as early as 2015. And of course, we all know we have the Transgender Act, Protection of Rights of the Transgender Act also of 2019 also. But still, we have initiated the move. Actually, we have pioneered the move. So what I was trying to tell you is, as much as there are needs in the society, the state has to bring about laws, or the state has to feel the necessity, what is the societal needs right now, and that is how they have to bring about amendments, or if need be, they have to introduce new laws also. Yet another important statute that I may bring to your notice is the Act of the year 2005. We have the Domestic Violence Act, and its protection of women from domestic violences of the year 2005. We have this act. Now, this act has brought about a lot of change from the societal perspective, sociological perspective. The reason being, basically, everybody tends to think that a domestic violence is related to something between man and woman. Need not be. So the Domestic Violence Act does not say whenever a woman is subjected to domestic violence in a shared household. So that can be from her parents, it can be from her in-laws. So that is how it can be from like two partners. And something which, though the live-in relationships have not been raised to a status of marriage, still this is one way of the law accepting, or rather recognizing, live-in relationships, so that a partner or a woman does not get abused or exploited by the partner. because all that you have to prove is that you have been sharing a household with your partner, and the partner has been abusing you economically, physically, emotionally, and mentally. And then you can approach the court of law and get protection orders, residence orders, and such orders which will protect you economically, physically, emotionally, and mentally. So the Domestic Violence Act has taken a major leap. Again, the importance of it at the cost of reputation, I may tell you, it does not specify that it has anything to do with simply a man-woman married relationship. It can be a shared household. But again, that is again the Domestic Violence Act. As per the Act, you have to initiate the proceedings before the magistrate's court. But there are so many decisions which state that in case if the domestic violence, if the provisions of the Domestic Violence Act have to be invoked, you can also approach the family court, because there's a recent decision by the Kerala High Court which says you can even initiate domestic violence proceedings before the family court. Of course, that is being considered by the Supreme Court now, whether that decision is correct, because the Domestic Violence Act, Section 12, specifically states that such complaints under the DV Act have to be, you have to approach the magistrate's court for it. If that be so, when a decision came that akin to it, in case of if it's between the husband and wife, the provisions of the DV Act can be initiated, or the proceedings can be initiated before the family court as well. So that I understand that matter is being considered before the Supreme Court. So that's the DV Act took a major leap for protection of women from domestic violence. But one major difficulty in that enactment that is also being brought to the notice of the Kerala High Court. We have recently filed a writ petition bringing that aspect to the notice of the Honorable Court, that if you have noticed, the DV Act does not have any provision for compliance or for execution of the orders. All that it says under Section 31 is, in case of violation of a protection order, you can prosecute the person who violates it. But other than that, there is no provision how to execute an order, execute a DV order, or to make sure that the order is complied. Now, what has happened is, there are cases, you must be knowing as practicing lawyers, you must be knowing there are lots and lots of cases where women get good orders, or rather very protective orders from the courts of law, but they are not able to get it executed or complied with by the police. The police is absolutely inactive when it comes to execution of domestic violence orders. What they say is, like, they give it the least priority, they give it the least importance. In spite of court orders, they tend to ignore it. One reason being that Act is silent about it. So that is one lacuna, or one gap that we have brought it to the notice of the Honorable Kerala High Court. Honorable High Court has been receptive to it. Of course, we know that it's a central enactment, so we have implemented the Union of India as well into the writ petition. That matter is being considered, because this is a major difficulty when it comes to DV, domestic violence cases. Then, of course, as we all know, one important legislation is the POCSO Act, Protection of Children from Sexual Offences Act. This act, again, as you know, that we have had a major turmoil in the country, a major mishap that took place in the country in 2012, when a girl was gang raped in Delhi at night. At night, of course, not late night, but still at night, inside the city of our capital in a moving vehicle. So that, of course, that brought about a lot of changes. What has happened brought about a lot of changes to the Indian Penal Code as well. Major changes were brought about. The definitions of rape were changed to an extent where grievous sexual assault and how people should be punished. Those people who are who have committed that particular act of inserting gruesome things to the private parts of the body of the women. So the concept of rape has been, or rather the definition of rape has been widened so much that it has been that includes almost any kind of sexual violation as far as women are concerned. Of course, that is in order to respect women in total, that such enactments or 2013 amendments have been brought, which a few of them I can bring to your notice is we have inserted 326A and 326B in the Indian Penal Code, which relates, that is, whoever causes permanent or partial damage or deformity to or burns or disfigures or disables any part or parts of the body of a person or causes grievous hurt by throwing acid on or by administering acid to that person or by using any other means with the intention of causing or with the knowledge that he is likely to cause such injury or hurt shall be punished with imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life and with a fine. So acid attacks have been taken into consideration, and it has been given prime importance as a grave offense itself by inserting 326A and 326B. Then, as I told you, the definition of rape under 375, 376, 376A, and 376B have been enlarged or rather widened to include whoever who penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her do so with him or any other person, or inserts to any extent any object or part of the body, not being the penis, into the vagina, the urethra, or anus of a woman, or makes her to do so with him or any other person, or manipulates any part of the body of a woman or so as to cause penetration into the vagina, urethra, anus, or any part of the body of such a woman, or makes her do so with him or any other person, or applies his mouth to the vagina, anus, urethra of a woman, or makes her do so with him or any other person. So almost any kind of violation of a woman's body has been brought within the definition of 375 and 376. Of course, even to an extent where sexual intercourse take place between a man and woman with consent also has been given a different outlook, to an extent where it has been divided as whether the consent has been given under threat or coercion or under a promise to marry. See, like there are so many, because basically women have been treated as vulnerable, though I do not agree to it personally. Otherwise, we know that women are being treated vulnerable, are being treated as a vulnerable group. And so it has, these laws have come into being that a woman can be tricked into sexual intercourse, or rather violation of her own body with against her will and pleasure, giving her a false promise that she would be married. So that the man would get married to her. So here again, there has been a differentiation. There has been a differentiation that has been brought about in the Kerala High Court. That is false promise to marry and promise to marry. See, there is something called like somebody who really wants to get married to X, a man who really wants to get married to X, and then they have consensual sexual interrelationship. And then at some point of time, the man is not in a position to marry X for some reason. For example, like they fall apart, or they have big differences of opinion between themselves, or the families are not for some reason, for some genuine reason that the man is unable to marry X, or he has taken ill. He has undergone some serious injury, or he has been subjected to some serious injury or some serious ailment, and he actually, not that he has entered into a sexual relationship with her with an intention not to get married. That is different from a false promise or a fake promise to marry. For example, a person has a sexual relationship with a woman, fully knowing well that he will not get married to her. So these are all things that have to be pleaded and proved before the court of law. It's not very easy, but then of course, a person's conduct before and after the offense can be very well judged by saying like which can attribute, which you can which you can, I mean, by which you can come to a conclusion whether there was actual intention to get married, or whether it was a fake promise to marry. So these are all different facets of the concept of rape that has been developed by the state statutes and legislature, and of course the courts of law. So the term consent itself has been given a widened scope. It's again a constitutional evolution. For example, recently we all know the POCSO Act, the 2012 POCSO Act, Protection of Children from Sexual Offences Act. It says any child below the age of 18, even if there is consent, it becomes an offense. But the period between 16 and 18 have now been sought to be treated as different. There is a hue and cry, or there is a jurisprudence that is attempted to be developed in order to bring about slight differences, because POCSO Act or POCSO law is very stringent. And as we all know, that if non-reporting also is very, very strictly dealt with. It invites penal action. So it's a very important thing that even the slightest knowledge that something like that has happened to a child has to be reported to the authorities. So what has happened is the age between 16 and 18, it is rather termed as Romeo-Juliet law, as you all know. I think again the Honorable Supreme Court has sought the opinion of the central government as to whether any changes have to be brought about in POCSO Act as far as the age between 16 and 18 is to be considered. Because apparently the children fall into relationship, and it's an age of very, very, I mean, that adolescent age is very inquisitive. So they all fall into a lot of issues where the young men, the young boys and the young girls are all trapped, or rather they fall into, they all come under the ambit of the POCSO Act, and their life is lost for good. So in order to avoid that, the Supreme Court is attempting to get information, or rather feedbacks from the central government. Apparently, the Law Commission has not advised so, because it will have a lot of conflict with the Child Marriage Restraints Act, and also the age limit that has been fixed for valid marriages by different personal laws. So all this can create a lot of hue and cry, but still, so perhaps that is one reason why the Law Commission has not given a green flag towards this Romeo-Juliet concept. But of course, the central government has, we have not come across any central government opinion on it as such. The Honorable Supreme Court has sought for feedbacks from them, or rather their opinions on it. So the evolution, that is what I was trying to focus is, whenever we have an act or an enactment, be it beneficial for the women as well as the children, there are a lot of interventions by the courts by which the law gets widened and becomes law of the land under Article 141 of the Constitution. So, so that's how it has been. And then, of course, we have certain important yet another important law that may be brought to your notice is it's the POSH Act. This protection of women from sexual offenses, sexual harassment in workplace. Because as we all know, we have had the Vishaka guidelines as early as 1997, because it's a very important area again, because a woman gets sexually, because for that matter, not alone a woman, any person who has to be productive in their workplace, you have to have the right ambience to work. So that's something which is common for any man or woman. So as a woman is concerned, her body, her violation of her privacy, violation of her body is very, very important. So sexual harassment can create a lot of, it's not just a physical impact that a woman gets as a result of it. It's more of an emotional impact that a woman has when it comes to physical harassment, sexual harassment. Because as we all know, there are so many instances or so many areas where women would not have come forward with complaints right on time, immediately after any kind of harassment that they have faced. They would not have come forward with any kind of complaint. And there are cases where the police as well as authorities ask the women, why have you come so late? What made you come here so late? It's like more or less like an afterthought. They are blamed like as though you have come here with an afterthought, like, you want to take vengeance on someone, or you are using this as a tool against someone. But it's not just like that. There might be people who misuse the law. I'm not saying they don't, but mostly what happens is when it comes to women, when there is a sexual assault, the women always tend to go on a sense of denial because it has an emotional impact. So what the women generally prefer to believe is that, okay, now this has not happened to me. Now it takes time for them to accept the fact this is something, that violation of their privacy is something which has happened to them, and more painfully if that has happened from people whom they are very close to, or rather emotionally very attached to. And then they realize that person has betrayed their trust and violated them. That is something which they will have to it gives them a sense of it minimizes their worth. It affects their self-worth. So that is one reason why women take time to come out of it, or rather, that is the time when they need a lot of emotional support. After emotional support, just not from the family and kith and kin, if need be, even from professionals, it's only after that most of them will be able to come out and make their complaints before the authorities concerned. Now, here you see that Vishaka guidelines, a woman who suffered this trauma, she carried herself through till the Supreme Court, got the highest court of law of this country to pass guidelines, and considered that to be law till 2013, when a statute actually came into being. That's perhaps after 16 years after the Supreme Court passed that judgment. So that law, that the fight which she has put up is something which is amazing and awesome, and it has been like in fact, the women of this country are actually indebted to her for such a the exercise which she has done. Now, the Vishaka guidelines came, the Supreme Court enacted the Vishaka guidelines as early as 1997. Of course, we were constrained to follow those guidelines as law, but then 2013, we have this protection of women, protection of women from the sexual harassment in workplace, where an internal committee, it's called the Internal Complaints Committee, but it has been again amended and it's now termed as internal committee, has to be mandatorily constituted in workplaces, be it public or private, where there are 10 or more employees. One important aspect is the term used in the enactment, except for the term aggrieved woman. Except for the term aggrieved woman and the title which says sexual harassment against women, the rest, most of it carries, it's a gender neutral term which says 10 or more persons are employed. It's very important because of late we realize whenever a query goes to places where they have a they have an internal committee in their offices. The first thing that they reply is, we don't have more than 10 women in our place to work. Who's bothered about whether they have 10 women or more? It's 10 persons. 10 persons or more, it's mandatory that you have an internal complaints committee. 10 persons or less, you have the local committee. Local committee, which is headed by the district collector. Of course, then it's notified, and then you have the constitution of the committee as under the POSH Act also. Now, the internal committee under Section 4 of the POSH Act, the local committee under Section 6 of the POSH Act, the constitution is in such a manner that it is headed by a woman, and more than half of its members are women. The reason being, essentially, the women show more of tendencies. I mean, they are more comfortable speaking out or talking to other women in general, rather than to men. But one important recent, I think it's yesterday, there has been a decision that has been passed. If I remember right, it's by the Kerala High Court again. which says, it says that unless and until a proper constitution, Justice Basant Banaji of the Kerala High Court, which says the constitution of the internal committee has to be proper and it has to follow the principles of natural justice. So the Act clearly states that on receiving a complaint, what to do. The rules clearly state, and the complaint can be preferred either by the aggrieved woman herself or through any of her kith or kin or any third person. You can make them give her in writing. It has to be given within 3 months from the date of occurrence, and further given another three months. It will be condoned for another 3 months because for some reason the woman is not in a position to give, but it has to be given in writing. The complaint has to be given in writing. And if she is not in a position to give in writing, because as I told you earlier, the women, once they undergo severe sexual assaults, it takes a while for them to come out of their shock and then do the needful, or rather approach the courts of law to set litigation, the law in motion. So they normally get the help of emotional help or support from other organizations, like there can be NGOs, there can be victim rights centers, there can be places who help them. So, and of course, the victim liaison officers are also expected to help them under the police force. So whenever they go to the police, or rather, once they reach the police, of course, they're expected to be taken over by the victim liaison officers, which mostly I don't think takes place as such, but they're expected to do that. Then, of course, there's a lot of NGOs. Of course, in Kerala, under the Kerala State Legal Services Authority, we have the Victim Rights Center, that has been functioning for more than 2.5 years. And in our model, I understand the Bihar and Punjab and Haryana courts are also, legal service authorities are also attempting to start the Victim Rights Center, in which it is basically for the benefit of women, children, and trans women. And the victim, as far as the guidelines of Victim Rights Center under the KELSA, Kerala State Legal Service Authority is concerned, it's a victim of circumstances. Victim under circumstances. It's a brainchild. It's a project which has been taken over by the KELSA, and it's a brainchild of Honorable Justice Mohammed Mustaq, who was then the chairman of Kerala State High Court Legal Services Committee. Of course, his lordship is now the chairman of KELSA as well. So that's how we function. So we actually, when a woman approaches us, we have a 24/7 phone number. When a woman approaches us with some kind of issue, we have NGOs who also functioning along with us, in addition to the pro bono women lawyers who function. And the women and the NGOs, immediately they extend their help of their psychologists, counselors, and social workers who attend on this victim. And once the victim is brought to a state, or rather she becomes emotionally stable, we help them. If it's a case of where we should approach the internal committee, we help them approach the internal committee or the local committee, or help them to approach the police and lodge an FIR. And of course, we stand by them throughout at stages of bail. We intervene in bail applications. We stand along with the prosecution, see to it the bail applications in cases of deserving cases. We stand by the victim throughout. Of course, in all cases, of course, and at times when we feel there are cases which are fake cases or which are made up cases, we advise the victim and see to it that she too comes out of that kind of an attitude, because we have been successful enough even for that, because we realize there are so many cases where, some cases, not so many, some cases where victims have been forced to give false cases. And there has been an instance recently when a case was brought before the Honorable High Court, and where a POXO matter, where the daughter complained against the father. And at some point of time, she gave a statement to the police saying that I was faking. And the police was also confused. And when the father approached the Honorable High Court for bail, the court was also slightly confused, because this girl keeps changing, speaking. I mean, like she is giving different versions. And therefore we were constrained. And therefore what happened was, excuse me.
You will have to unmute yourself.
I'm sorry about it. I'm sorry about it. What I was saying was, like, when such a confusion that arose, the court was also finding it difficult as to how this was happening. And so what the court did was, the court asked one of the Victim Rights Center members, the members of the Victim Rights Center, to intervene and speak to this girl to find out, like, why she has said so, or meet the victim in person. So we called the victim and her mother also. Her father was had applied for bail, and he was remanded also. And the whole family, the mother's brothers, and the girl, everyone came to us. And we had a psychologist also along with us. The Victim Rights Center, of course, it's an in-house arrangement. And with the help of the psychologist, we had a one-to-one exclusive talk with the daughter, who was the complainant, de facto complainant. And after about 1 hour, she just broke down and she said, it's just because I was having a relationship with a third person. It was on social media. I met somebody on the social media, and I was having a relationship with that boy. And I had made a few attempts to elope with him as well. So that was the reason my father was dead against that. So my father was, perhaps he was not allowing me to use the phone also. So at that point of time, I was constrained to make this false complaint against my father. So such things also happen, not intentional misuse, of course, but such things also happen. And so that was the time when we reported before the court. Also, we got this girl counseled well. Now she's doing very well in her studies. So these are all areas where we can intervene also. So all these are all paraphernalia of the system, which can help. Because ultimately, everything, the law, as I told you earlier itself, the law is interconnected with the societal acts, lot of societal aspects and sociological concepts. So considering all this, we have, as I told you, the POSH Act, the Internal Complaints Committee, Local Complaints Committee, and it's mandatory that the internal committees are formed in all places of employment where 10 or more employees are there, which is headed by a woman, and more than half of its members should be women. Then, of course, we have the health rights of women. We have the MTP Act, the Medical Termination of Pregnancy Act, and how the different changes that have been brought about. These are all, and again, court's interventions. As you know, the important decision by Honorable Justice Nagaratna and Justice Hima Kohli recently, by the Honorable Supreme Court also. So considering the benefit of women, and considering the health condition of women, considering the overall benefit, the courts also step in and make necessary laws in such a manner that the women-centric laws are beneficial, or rather, it comes to the aid of women in general. These are basically, I think, we have almost covered the basic laws. Of course, there are so many areas. If you ask us, there are so many areas which are beneficial for women and children as such. There are so many areas where laws have intervened for the benefit of women and children. But then these are the major laws which have come to the aid of women in this country. Because, Ji, I think we are through.
So, ma'am, what is your ultimately, finally, how do you conclude that? What is the journey if we have to complete it in 2 minutes?
Okay. So shall I come to the conclusion part of it?
Yeah.
So I conclude this class. The basic thing which I would like to place before all of you is, It is not a lack of the number of laws for the benefit of women and children in this country that have created issues for them. It is basically the attitude of the society, as I told you earlier itself, unless and until we make use of the laws by responding and reacting to situations, we are in a position. Again, one of the important aspects which I may bring to your notice is the Legal Services Authorities Act. The Legal Services Authorities Act, Section 12C, specifically states, irrespective of the income of women, and children, irrespective of the income for women, of course, children do not have income. Irrespective of that, the women and children are entitled to free legal aid. So tomorrow, even the richest woman in this country comes to a legal services authorities, they are entitled to free legal aid in this country. So that means the access to justice is not being denied to women and children on any ground. If that be so, we should not misuse it as well. All the same, we should be able to use it in the most dignified manner to see to it that the law is set in motion and the laws come into force in full-fledged. As I told you earlier, there are so many laws that are prevalent in the country, but that is because, for example, the Dowry Prohibition Act, I'm talking to you from our state's perspective. About in the span of last 3 years, we have had back-to-back cases where 2-3 girls two of them were murdered. One committed suicide. Two committed suicide. 2 were murdered also. So in the span, and that was the time when our state itself, it created a lot of hue and cry in the country, in the state. A lot of public uproar was also there in the state, and this resulted in bringing up they started looking back into this Dowry Prohibition Act and see to it that and booked the person the accused under Dowry Prohibition Act as well. So unless and until this act, these enactments or the statutes are brought or are made use of, there is no point saying that we do not have laws. We do have laws, but please see to it that maximum use is made of these laws by creating legal awareness among women and children, make them aware, and also guide them to use it in the best way possible and not misuse it also. Because there are cases where under Section 498A, again, we know there was an important case by the Honorable Supreme Court, where 498A cases, there was a suggestion by the Honorable Supreme Court that we should have a board to filter and decide whether the 498A cases have to be taken forward at all, because random people are being made parties into the litigation. The sisters who have got married and who are living elsewhere are also made parties by the women, the sisters-in-law. They're also made parties to the litigation. The aged mother parents are made parties to litigation just because they have differences of opinion with their husbands. But in such cases, the women's commissions in different states also got themselves implemented and said, not now. Let women be given the prime importance right now. So that's how, we have to respond and react to whatever societal changes take place, and then make maximum benefit, maximum use of the laws, beneficial laws in the favor of women and children, but never misuse them also. Thank you. Thanks.
Thank you, ma'am. And I believe that with the legal aid services coming into being, and people like you and the NGOs, they will play a pivotal role, and people will be sensitized, and there will be more empowerment. Thank you, everyone. Stay safe. Stay blessed.